We have a lot of folks here from the National Labor Relations Board, and this is going to be a segment of the program dealing with the National Labor Relations Board. And I'm very pleased that Peter Robb has come back here as our luncheon speaker. I'm very, very pleased. Peter Clark, who's a longstanding friend of the Center for Labor and Employment Law, was a supervising attorney at the NLRB. He tells me that was just after Taft-Hartley was passed. I said, that can't be. That cannot be. Neither of us was there at the time. He's a very knowledgeable person. He's in the field of labor law. He's with the firm of is it still called Kauf McLean?
No, Kauf McGuire and Margolis.
Kauf McGuire and Margolis. I remember Maureen McLean. She was a spirit of nature, and she was a force. In any event, it's a very fine firm, and Jerry Kauf is a member of our advisory board. So I'm going to turn it over to Peter Clark. Oh, before I do that, RAIL, it's a great acronym. It's the Journal of Robotics, Artificial Intelligence, and Law. We've just given you free copies. Steve Eric is a very good friend of ours, a very good friend of the center. He is the publisher of a company called Fast Case, and I think we have a table outside. You ought to take a look at what they can offer as an alternative to Bloomberg, Lexis, Westlaw, Justia, any of these other publications. Back to Peter Clark.
Hello, and I'm grateful for the privilege to introduce to you the Honorable Peter Robb, General Counsel of the National Labor Relations Board. For those few of you who may not be familiar with the National Labor Relations Board, the General Counsel is nominated by the President for a 4-year term with the advice and consent of the United States Senate, and the General Counsel of the NLRB has independent authority to investigate and prosecute unfair labor practice cases before the board and its administrative law judges, and the General Counsel exercises general supervision of the NLRB's regional offices, which process all cases, or at least initially process all cases at the NLRB. Those are secret ballot elections for employees in private industry who want to choose whether or not they will be represented by a labor union in collective bargaining, and in unfair labor practice cases. All of that runs through the regional offices, and not much of it runs up to the desk of the General Counsel when things are hot and heavy. Unlike cabinet secretaries, the National Labor Relations Board General Counsel does not serve at the pleasure of the President and is removable only for cause. That's not quite as good as lifetime tenure, but it's not bad. General Counsel Robb's appointment began in November 17, 2017, and he continues to November 2021 after the next national election, regardless of the results of that election. Mr. Robb graduated from Georgetown University with a degree in economics, and he earned his law degree cum laude from the University of Maryland. Mr. Robb's past government service included appointment as a field attorney in the NLRB's Baltimore Regional Office. He moved on to being a supervising attorney, something I can identify with, at the Federal Labor Relations Authority. And then he moved back to the Labor Board to serve as Deputy Chief Counsel and subsequently as Chief Counsel to then board member Robert Hunter. After his government service, he entered private practice in Washington, D.C., moved on to the firm of Downs, Racklin, Martin in Vermont and New Hampshire. And since I'm a native of Maine, Vermont and New Hampshire are close, but not quite the same thing. But Mr. Robb has redeemed himself, as far as I'm concerned, by maintaining a cabin in Maine where he particularly enjoys getting away to go fishing when he can escape from Washington. Please join me in welcoming Peter Robb to NYU's Labor Law Conference. All yours.
Thank you, Peter. I thank Sam, who just snuck out on me. I don't think it's a reflection of what I'm going to say, but and everyone at NYU for inviting me, especially inviting me back. It's nice to know that somebody wants to hear you speak again after you've spoken. I was thinking about this topic of artificial intelligence and how that would relate to things that we do, or what I could say about the NLRB. And it struck me how artificial intelligence has crept into our lives so much that we don't even think about it anymore. I was watching a baseball game the other day on TV, and they talk about, they have pitch counts that now appear on the screen. They have little boxes that are supposed to show you balls and strikes. They have the fielders moving in different spots on the field. And all of this, I think, is being computer generated, because they're putting, baseball's always been a statistical game, but they're putting more and more statistics into baseball. And it's causing the decisions, and it's getting to the point, I think, where managers are going to be, have a difficult time not following the statistics. That is, making their own decisions on things, which I'll come back to at the end. Coming down here, I had to go in a vehicle to get here from where I'm staying in New York. I was also thinking about artificial intelligence in terms of driving cars. I think we've all seen that recently, that now we have that capability. And I don't know about you, but when I first heard that, I went, oh God, I don't want a machine driving a car plowing into me. But as I was watching people driving here in New York, I was thinking, you know, not a bad idea maybe. Bad or good, I think it's probably coming. And it's probably coming because machines are probably more predictable and make fewer errors than humans do on things. I don't think we can stem that tide. So it's crept into our lives, and I think that's happened at the NLRB also. It's not so apparent when you look at the functioning of the offices. You all now can submit documents, file charges, and do things online using forms that weren't available, but you probably take it for granted. But it hasn't been really an easy transition, shall we say. We've spent, the board has spent the last decade approximately $52 million on getting new technology, most of which is artificial intelligence, for our computer systems. This past year, we spent, in our spend plan, we have $15 million for the year for our computer systems, 2.5 million of which is for new equipment. The remaining 13 million is for maintenance, simply maintenance of the equipment. With about 1,300 FTEs, that's about $10,000 per person on simply maintenance. And that doesn't take into account training and a bunch of other things that we do. So there's been a heavy investment, and I thank my predecessors, especially the more recent ones, Ron Meisberg, Leif Solomon, Dick Griffin, for developing this capability that I'm now able to enjoy. We have a system called NextGen for the field that is a computerized filing system. We have moved our filing to the cloud last summer, so we have unlimited and speedy access, such that if there's a charge filed against an employer, anyone, including me on the GC side, can go into NextGen and see all charges over the last, well, since at least 2001, I guess, filed against that employer, every document in every case. It's immediately accessible. It saves a lot of time. Our forms are accessible, such that when our NextGen system goes down, which it does periodically, and it has, I think we've done a lot better more recently, but it's hard for our staff to do their jobs when the system's down, similar to private practice. I was pleasantly surprised when I came here that the computer systems were similar to those that I think the big law firms have. And our capability is similar, which really helps us in our litigation. So we don't have handwritten affidavits anymore. We don't have a lot of typing. There's a lot of email that's going back and forth. All of that, of course, has had an effect on us, an effect on our workforce, too. In 2016, Dick Griffin looked at the support staff, the administrative professionals that we have, and at that time, there had been a ratio of 1 administrative professional to every 2 professionals in the field, and that had been there for decades. He changed that to 1 to 4, so it's 1 administrative professional to every 4 attorneys. 1 to 5, excuse me. Obviously, we're still wrestling with the fallout from that. Dick decided that he didn't want to involuntarily separate any of our great administrative professionals, and something I agree with, and that's going to continue. But the question is, how do we manage the staff? So it's been attriting down. When you have attrition, it doesn't always come in the right offices. So we have imbalances now from office to office in our administrative professionals. Our caseload has been declining for the past 10 years, as you all probably know, and that is having an effect on the workload in the various offices. So that's another factor that's making it difficult for us to deal with the impact of artificial intelligence. So we are now in the field. I'll give you an idea of this. So we've had, in the last decade, about a 17% decrease in staffing overall. It's been similar to the decline in caseload. So over the last 9 years, the case intake decrease has ranged from 0.35% to 9.32%. The field staff decreases ranged from 1.29% to 11%. So somewhat similar, but in addition to that, of course, you have the impact of technology on our offices. In 2017, there was a 9.2% decrease overall in case filings, and field staff reductions were 4.49%. The reason I'm saying this is because this debate is in the public already, and is something that affects the practitioners. And I think the debate is fine. It should be based on facts, though, not speculation or a comment that somebody made. So I had to ask my staff to go back and let's get some facts. In 2018, there was a 2.75% decrease in case filings and a 6.5% decrease in field staffing. So if you look at those 2 years together, you can see that it's pretty similar, the decrease in staffing in the field and the decrease in caseload. What's hidden there a little bit too is that some of the field work is now done in headquarters of necessity. We have had unprecedented numbers of FOIA requests since I came on board in 2017. Not directly related to me, but I think related to the change in administration. We've also had an unprecedented number of congressional inquiries and requests for data. Consequently, we've had to use more people on that. We consolidated the FOIA, the Freedom of Information Act cases in headquarters a while ago. We've consolidated press inquiries since there were so numerous responses in headquarters, and we have consolidated the responses on congressionals in headquarters also. All that was done prior to my coming, and I agree with it. In addition, some of you may have noticed this, there have been some ethical issues that have been raised, and we seem to have an unprecedented number of ethical issues on tap these days. So, where are we for looking at 2019 fiscal year, which started on October 1? So through May, interestingly, our caseload for C cases, unfair labor practice cases, has stayed virtually steady. It's about a 1% increase, actually. That's contrary to the steady decline we've had before. I don't know whether it'll hold for the rest of the year, but it's interesting. At the same time, there's been more than a 5% decrease in our case filings. So we have that, which puts us overall at a slight decrease, but not too much in overall caseload. But here's the real problem. If you look from region to region, for example, I'll give you some examples here. Boston, over the last year, year-on-year, calendar year, so if we compare November, the month of November this year to last year, the filings in C cases were up 21%. But in February, if you compare year to year, they were down 28%. Overall, Boston is seeing a 13% decrease in C cases over the course of the last year. Baltimore, on the other hand, saw a 37% increase in C cases filings in October, and then had a 41% decrease in January. Baltimore is down 3% overall in C case filings. But if you look at Atlanta, they're down 38% overall. St. Louis is down 23%. These are all C cases. Cleveland is up 20%. Puerto Rico's up 41%. And again, obviously, most of the other regions are up to a certain degree because we're running about even. So, how is that affecting us? It's making it difficult for us to figure out where to hire, when to hire. We've been holding off a little bit during the year, but we now have 18 positions that are being hired for the field. These are professional positions, examiners and attorneys, and I think we have another 4 outside the professional ranks, I think 3 of which are administrative professionals. We're trying to match them to the right regions. Inevitably, though, we're going to have to deal more sharing from one region to the other and moving cases from one region to the other. So you're going to see that happen. And that's largely as a result of the artificial intelligence gains we've had with our systems now. We can do that more readily. So where are we on all of this as far as the performance goes? I think we have some people from the regions here. Could those people stand up? Would you mind? The NLRB people from the regional offices. We have quite a few. Great. I would like to thank you and publicly acknowledge what a fine job you have done over the last year. Last fall, we had set a goal for the agency to try to become 5% more timely in our processing of cases. Due to the efforts of the people that were just standing, so far to date this year, on our main statistic for the field, which is the time from filing of a charge to disposition of the charge, it's decreased from 90 days to 77 days. That's almost a 15% decrease so far just this year. Another lesser factor, but one we look at, is the time it takes from settlement to disposing of the case overall. That's decreased overall in the field from 172 to 163 days. That's 6%, which would exceed our goal on that marker also. And we're constantly monitoring the quality, and there's been no drop-off in the quality of the cases. So the staff is doing just an outstanding job in meeting our strategic goals. We're doing the work faster, more efficiently, and as I say, maintaining the quality of the work that we're doing. So where are we going at the board with artificial intelligence? There has been a lot of comment about rulemaking at the board and using that more often, you'll get a chance to talk to the chairman. I think tomorrow, if you're here, you can ask him questions about that. But let's look beyond that to artificial intelligence. Can the board use that in a different way? One area that's been a persistent problem is rules that employers have for employees. There are more and more jurisdictions that are requiring rules and of various kinds, and employers on their own want to have rules. So is there some way that artificial intelligence can be used so that someone could submit a proposed rule and the artificial intelligence would tell them whether that rule would be lawful under current board law or not? Probably could. For all I know, maybe there are some law firms out there who have such a program where they try to predict where the board's going to go. So that's one area that it's possible, I think, to use artificial intelligence in the future. When you think of all the different law firms, board agents, and others who are reading the same cases over and over again to try to come to the same conclusions, it doesn't seem to be very efficient. Just how that would play out and how well it would be received, I don't know. I probably certainly won't have to worry about that in my tenure as general counsel. But someone else may be thinking about it later on. Another area that I think is very ripe is where we have union activity or protected concerted activity, and the employer wants to use some kind of criteria or programs for hiring. Are those programs going to discriminate against employees in terms of the National Labor Relations Act and their desire to engage in union and protected activity? Is there some way that artificial intelligence could help identify the biases against that and identify unlawful ways of trying to screen out people? We know that we've seen that in some other areas, impact on discrimination in the EEO context, but we shouldn't exclude that from the context at the NLRB. So that's another potential area where I could see in the future someone looking at that. It will require some change in the way everybody's thinking, but as I said before, that's already happening. The way we react, the information that we get, artificial intelligence is influencing us every day more and more. Okay. So some of you may be here for continuing legal education credits, so I thought I'd talk about a couple of legal things just so you can say that you're here doing that. So I'm going to talk about a couple of cases I just want to alert you to. Now, each one of these cases, understand that consistent with the memo 1802 that I put out when I first came, in these cases I'm arguing for current law to be applied even where I disagree with it. I'm also putting my own views if I have different view than law. But the complaints were issued, the cases are being litigated, the positions in front of the board include positions that support prior case law even where I disagree with it. So the first one I'll just briefly mention is ADT LLC. I'll give you the number. The JD number is 74-18. So this is a judge's decision on 885 and 1. The reason I'm pointing this out is that it deals with dues checkoff and the obligation to continue dues checkoff after expiration of contract. There's prior board case or two dealing with whether the language in the dues checkoff should allow it to continue or not. I disagree with some of the recent cases on that and think unless there's clear language that the dues checkoff should continue, it shouldn't. There shouldn't be an assumption there. Next one is MV Transit, sometimes known as MV Transportation. That's a JD 0119. In this case, this deals with a case called Staffco of Brooklyn, or a principal that was involved in that case, 2016 case. This deals with the employer's obligation to continue to make contributions to pension in a successorship situation. And in particular, what I've focused on in this is the part of the case law that states that even where the pension plan itself, as well as the contract, prohibits continued contributions in the plan, the employer has to continue to make contributions and put them aside in some other kind of plan that has not been negotiated. So the position I'm taking there is that there is a duty to bargain about that, but if it's not possible to continue pension contributions to a particular plan, you do bargaining. You don't require an employer to set aside the funds separately, and that implicates other laws too. Windsor Sacramento Estates is another case, and this one's winding its way up. This is 20 CA 196183, and this deals with the mandatory arbitration, that the issue that's kind of left open under Boeing, which is language in some of these mandatory arbitration provisions that require the employee to either exclusively use the arbitration process or use the arbitration process, and whether that's unlawful or not. So the board is going to be deciding that. My position is that it should be analyzed under the board's more recent Boeing decision, and that if you do that, you're going to be balancing and you're looking at it at the language. You won't assume that it's going to prohibit filing of unfair labor practice charges unless there's some language like exclusive. So if it says this is the exclusive way an employee can challenge a particular action, that would probably run afoul, in my view, of the act. But if it doesn't say exclusive, I don't think the board should be assuming it. The last one is 800 River Road Operating Company. This is another case that has not been to an ALJ yet. It's 22 CA 204545. And this case deals with Total Security, a board case of recent vintage that put a requirement on an employer that after a union has been newly certified, the employer must bargain to impasse with the union prior to affecting serious discipline. I don't believe that that is consistent with prior case law. The status quo prior to the union becoming exclusive rep is that the employer can, where the employer has been and can affect serious discipline, it's not a change for them to continue to do so. So those are those cases. So you got some legal stuff from me also. So that's basically my presentation. I can entertain questions if anybody has any questions.
If you have a question or comment, please come to the
Except
microphone.
Except for Sam.
Yes, I have an ambulatory right to ask questions at any time, with or without notice, and with or without cause. Would you come to the, Larry, it means you. Would you come to the microphone and identify yourself?
Hi, my name's Larry Nathan. I'm a union attorney. When a contract expires, what elements of those contracts continue, and how does it relate to the dues checkoff?
Well, the wages, hours, and working conditions continue. The checkoff, it would depend on the language.
There's no language.
If there's no language, in my view, the checkoff doesn't continue.
Okay, thanks.
Feature of the contract. we'll see what the board says.
Is that the current board policy? I forgot.
No,
So
it's
this
not.
is a place where you're going to ask them to change it?
Yes.
Okay. Other questions or comments? You've got the most important sort of control point for the NLRB right here. Cases have to be, complaints have to be issued before anything gets to the NLRB. Matt, any questions from a former board lawyer? Take advantage of the opportunity. No? Any questions or comments? So I had to go out for a few seconds. So what is the open issue on mandatory arbitration clauses?
The open issue is whether a clause that has language that says this is the exclusive way, or this is
I see.
the
That part.
forum for an employee to raise certain
Right.
employment issues,
Right.
whether that is unlawful in and of itself.
Right, because it's incorrect about your NLRA rights, which can't be superseded.
Well, you
Yeah.
can't, yes, you can't
What-
prohibit somebody.
What about firing an employee or a job applicant who declines to sign such a clause? Is there an issue under the NLRA?
I haven't seen that come up yet. I haven't had a case on that.
I understand, I was asking you. We've had some cases where we've convinced the employer not to do that. But
Well,
there are
that's
issues.
advice. That's
Yes,
different-
I know,
that's
that's
different
advice. Matt, Professor Bodie from St. Louis, who's going to be, by the way, the new editor of the NYU Annual Conference on Labor. It's going to become part of the American Bar Association's Journal of Labor and Employment Law. It's a new partnership, and I really welcome it, Matt.
Yeah. Yes, and we're very much looking forward to working with those of you who are presenting as well. We were actually, a few of us were talking at lunch. We were wondering, mandatory bargaining about employee data. Have you seen anything on that, and what would you have any initial thoughts on whether there would be a requirement if an employer is collecting data about employees, would that be a mandatory subject to bargaining?
Probably would depend, in my view, on the context. I tend to try to look at always the context and information requests. One of the things that has come up that is got me thinking a little bit more on information requests is we get a number of situations where there's a request made, could be a union or employer, more typically a union, and the employer makes a response, says it's overbroad, says it's confidential information, and nothing else happens. So the charge comes up. So by that time, I think usually the lawyers have gotten a hold of it and now have perfected some kind of abstract reason why or why not their position is correct. One of the things I would like to see is the board encouraging, maybe even requiring, that the parties engage in some dialogue on information requests before that. So when the case gets up to the board, we're dealing about what actually was the difference of opinion at the time between the parties. So I look at all of these kinds of requests, you know, in the context that they were made.
Thanks.
Other questions or comments? Peter Clark, is there anything you'd like to say?
Oh, no, I think it's all covered.
Peter, that's a terrific statement by a moderator. Is there anything else you would like to say, Peter Robb?
Well, the only other thing I'd like to say is that perhaps a little bit unlike the board members, people can actually talk to me if they have cases. I usually ask people to put things in writing, and then I will run it through my staff. But my Associate General Counsel, Alice Stock, is here.
Who's here?
She probably knows everything better than I do about the GC's office, so we're somewhat interchangeable. You can talk to Alice, you can ask me. I try to keep very open, and I do get, you know, a fair number of inquiries, and I don't mind at all. I think that's
Peter Robb has the best lawyer's job at the NLRB, in my view. It's a really interesting job. Thank you
Well,
very much.
I'll tell you in a couple more years whether I agree with that statement or not.
I thank you very much for coming,
Well,
very
thank
much.
you.
Please join me, thank you.